Hello everyone, as promised, we've got the next bit in Bartz v. Anthropic. Not one but two documents have dropped. And if you remember where we left off, Anthropic, who has basically won the case, has appealed because of the one part they didn't win. And this was basically the idea that since they kept a copy of the training data, that they can claim fair use on that if they're using it for something else other than AI training. Well, Anthropic's response was, but we're an AI company. That's all we do. What do you think we're going to use it for other than AI training? So they won an interlocutory appeal up at the Ninth Circuit, or in the alternative for Judge William Alsop to reconsider that part of his opinion. Sounds fair enough, right? Well, of course, the plaintiffs don't like that. And if you remember, these are the Bartz plaintiffs. These are the ones that were in hysterics. If you haven't seen that video, I highly recommend it so that you can see what these plaintiffs are like, and they do more of it here. Wow, all these different lawyers that they have, most of them are pro hoc vice, which means they're from out of state. So they've been bringing in the big guns from all over the country. And that kind of puts the lie to the thing, because the impression the media has of these cases is, oh, these are just authors who kind of passed the hat and got their pennies together and bit. No, they got a whole army. They are backed up. They're backed up probably by the Authors Guild and the publishing houses and things like that, but they're doing it on behalf of the individual authors. And so they can say, oh, we're just individuals against this big bad corporation, Anthropic. Anthropic is not a big bad corporation. It's a startup. And it's a PBC, a public benefit company. And like I said, all it does is AI. So that's what all this is about, is AI. And Anthropic, in their appeal, they were like, what are you talking about with this building a separate library? Nobody ever brought that up before. We never got a chance to respond to those arguments. And you're going to rule based on that? We either need an interlocutory appeal or we need you to reconsider. Because it's just not fair if you're going to rule based on arguments that we never got a chance to respond to. So, they made the motion. Remember, I've covered the way this works. When one side makes a motion, the other side gets to respond to the motion, and then the first side gets to reply to the response. And that's exactly what's happening here. We've got the plaintiff's opposition, and that was submitted on the 28th, but for some reason it took a couple of days for it to show up on Court Listener. But we've got it now. And then yesterday, Anthropic gave their reply. So we'll look at this motion to stay. We won't go over it in the details because the details are reiterated in the reply. So there's no sense in saying it twice. But we do want them to have their say so that we can start here over on page 5 of the PDF file. This is the first actual page of their response, where they say Anthropic has shown no basis for a stay. Weeks before summary judgment briefing began, plaintiffs discovered that Anthropic torrented troves of books. Okay, this torrenting thing is new in the case. If you remember, we talked about the torrenting, but that was over in Kadrey v. Meta. They didn't accuse Anthropic of torrenting, but again, they're losing on everything else. So they have to be copycats every time there's a little bit of an indication that something might get traction, they gotta stick it in. And so we can probably see this claim in the other AI cases as well. Torrented troves of books from two notorious criminal enterprises. Yeah, what did I say about hysterics? Notorious criminal, like what, they got it from the mafia? One was the mafia and the other one was the Mexican cartel, I guess. Anthropic now changes course and asks the court to pause everything and deprive plaintiffs and scores of copyright owners of their day in court. They won't get their day in court. It's an interlocutory appeal. Get over it. Get over yourselves. Anthropic cannot satisfy even a single factor required for a stay. Anthropic identifies no substantial question likely to yield a reversal in its not yet filed Rule 23F petition. If it's not filed, then how do you know they haven't? But they have actually. The whole thing about them supposedly building a library for purposes other than AI training, that, like I said, they never got to respond to that. Anthropic offers only speculative, self-serving purported harms that are indistinguishable from the ordinary burdens of litigation, while ignoring the harm suffered by plaintiffs and class members whose pirated copyrighted works remain in Anthropic's files to this day. Just them existing is an irreparable harm. Far from serving the public interest, a stay would reward Anthropic's strategy of hiding its conduct from the public. It's a public, everyone knows that they tell people what they're doing. They know what they're doing. We know how AI training works. And those harmed by its infringement. If the law is against you, pound the facts. If the facts are against you, pound the law. If both are against you, pound the table. Just like they are. Anthropic's proposed Section 1292B application merely repackages the same characterization of the facts the court rejected at summary judgment. Yeah, that's why it's an appeal. And they likewise recycle the arguments this court has already considered and rejected in its thorough class certification order. Do you not understand what the point of an appeal is? That's what you do during an appeal. That's what an appeal is for. We think the judge made a mistake. The court's class certification order, moreover, follows settled precedent allowing copyright classes. Notice they don't actually give any support for that. We'll get into that though. Where common questions, here whether Anthropic unlawfully pirated troves of books, Napster style, Napster again, yeah, gotta pound the table, predominate over any individual issues. Trying this case on the schedule set by this court nearly 10 months ago is not the sort of irreparable injury that justifies a stay. Anthropic's lament that it will suffer reputational harm if this litigation proceeds is self-serving fiction. Worse, it ignores that the facts about which it is concerned are not speculation, but flow directly from Anthropic's own admissions in an already public record whose development Anthropic sought to expedite via early summary judgment. By contrast, delaying trial would prolong the ongoing infringement and postpone any relief for plaintiffs. So that's their claim. They try to defend it, and we're going to see how well that defense works. Here in Anthropic's reply, here on page 3 of 10, where they say, under the current schedule, in the next 4 months, this litigation will proceed to a massive, first-of-its-kind class action trial, exposing Anthropic alone to potentially hundreds of billions of dollars of liability over conduct that is common across the generative AI industry and that another court in this district has deemed fair use. And that's a problem. You got one judge saying one thing, one judge saying another. Why don't we go ahead and take it up to the Ninth Circuit and see what they say? See my previous coverage on this. I went over all that. I don't want to reiterate. Plaintiffs have had and will have their day in court. Of course they will. Because that's not what this is about. God, it's an appeal, people. It's an interlocutory appeal. Anthropic simply asks for a pause that allows meaningful appellate review first. Anthropic respectfully submits that the court should review the forthcoming Rule 23F petition before deciding Anthropic's request for a stay. And by the way, this is it. So Anthropic made the motion. The Bartz plaintiffs issued the response. This is the reply to the response, and that's it. That's the final word. The judge will make his decision based on this. So they're asking him to just review the petition before deciding Anthropic's request for a stay. That petition will demonstrate that Anthropic has, at a minimum, a fair prospect of success in obtaining immediate review of the court's class certification decision, which presents unsettled questions about the application of Rule 23b3's predominance requirement in the copyright context and creates immense settlement pressure that may make end-of-case review unavailable. Because if they settle, you can't appeal that. It's a settlement. And that's what a lot of these cases are about. You don't sue because you're in the right. You sue because you've got an army of lawyers and you can sue them for $80 bazillion and you bully them into a settlement. That's how the process works, and things like interlocutory appeals are, in part, meant to protect defendants from that kind of bullying, the very kind of bullying the Bartz plaintiffs are doing against them. Likewise, Anthropic's motion identifies controlling and uncertain questions of law from the court's summary judgment order that would benefit from immediate appellate review. Plaintiffs face only a delay in potentially obtaining money damages, And remember, this is all about money, so none of this is irreparable. If it can be made up for with money, it's not irreparable. That's what the courts have said. Which pales in comparison to the unrecoverable economic and reputational costs Anthropic will suffer as this case speeds through class notice towards trial. It's just 4 months. That's nothing in, court trial time. And the public will plainly benefit from ensuring the judicial and juror resources are not wasted, and that this and other courts have the benefit of clear appellate guidance regarding the important issues presented by this and many similar cases. A stay will benefit all and should be granted. Alright, moving into the weeds here on page 4 of 10. Just 10 pages, won't take long. Well, 6 actually. The standard does not require extraordinary circumstances, as plaintiffs suggest. Rather, Anthropic need only show a fair prospect of success on the merits and can readily do so here. Although plaintiffs attempt to argue otherwise, there is nothing improper about Anthropic seeking a stay now and in this court. In fact, the federal rules require Anthropic to first seek a stay here before seeking one from the Ninth Circuit. District courts in this circuit regularly stay their own proceedings while a Rule 23F petition is pending in order to ensure appellate review before trial. This is nothing extraordinary, it's routine. This is what happens. And this is precisely the sort of case where interlocutory appeal is warranted under each of the 3 independent criteria from Chamberlain v. Ford Motor Company. Copyright claims are generally poor candidates for class action treatment, according to Schneider v. YouTube. And plaintiffs identify no precedent for a copyright class of this size, nature, or complexity. This court's decision to certify a class with millions of members and claims, each of which will present individualized ownership and fair use inquiries, among others, raises novel questions likely to recur in other similar cases. Those unsettled cases will also evade end-of-case review, if not addressed now, because of the substantial settlement pressure the class certification order exerts. And one more thing to know about class action lawsuits. If you're a member of a class in a class action lawsuit, and you actually win, you basically get nothing. You get pennies. Who makes out? The lawyers do. Yep, all those Pro Hoc Vice ambulance chasers we looked at the start. That's who makes out in a class action, and probably the publishers too, based on the agreements they have with authors. I mean, God. Authors and publishers and musicians to record labels, that sort of thing. That's pretty much the only kind of feudalism we have left here. That's what it is, it's feudalism. They fail to account for the many individualized issues presented, including ownership, registration, validity, substantial similarity, and damages. How do you do that for an entire class when they're all going to be different? Plaintiffs are thus simply mistaken to assert that Anthropic appears to acknowledge there is no manifest error, and that Anthropic does not suggest a misapplication of any element under Rule 23. Third, the class certification order creates immense pressure to settle for Anthropic, which may prove the death knell of this case. Plaintiffs incorrectly accuse Anthropic of strategic exaggerations of potential liability, ignoring the actual stakes of this case as reflected by the court's class certification order. Up to $150,000 in statutory damages per work, with up to 7 million works at issue. I did the math on that, and at a maximum, that's over $1 trillion. So they're not exaggerating with what they say next. If anything, they're lowballing it a bit. A damages award of that magnitude, potentially hundreds of billions of dollars, would be devastating for Anthropic, or indeed almost any company, regardless if it had billions in annual revenue. That would still take them centuries to pay off. This court's order raises 2 controlling questions of law, resolution of which may materially advance the ultimate termination of the litigation. First, whether fair use is analyzed based on the defendant's ultimate purpose in copying a work, or instead based on separate constituent steps. Remember, we talked about that dichotomy earlier, so check my earlier reporting for more details on that. And second, whether a defendant's initial acquisition of a work from a third party who distributed it without permission counsels strongly against fair use. These issues are not, as plaintiffs contend, fact-bound. They're matters of law, not fact. Under a different, and Anthropic submits the correct legal standard, the specifics of Anthropic's acquisition and storage of pirated works obtained for the ultimate purpose of training its LLMs would not undermine Anthropic's claim of fair use. If it's fair use, it doesn't matter how you got it, as I've covered repeatedly, lots of times. And Judge Chabria's conflicting decision in Kadrey v. Meta proves that reasonable jurists might disagree, because they already have. And remember, we talked about that. That's why, hey, one judge is saying one thing, and their trial's going to go one way, but this other judge is saying a different thing, making the trial go the other way. One way or another, that's going up to the Ninth Circuit. Why not go ahead and get an answer now? That's what they're asking for. Plaintiff's opposition severely misconstrues Kadrey. First, Judge Chabria did not decline to certify an interlocutory appeal of his summary judgment order. And when I was reading that part of it, I was like, what the hell are they talking about? Which no party moved for. He instead declined to sua sponte enter partial final judgment in favor of Meta, which Meta had suggested as an option after plaintiffs in that case retreated from an earlier proposal for immediate appeal. Second, Judge Chabria did not order supplemental briefing on piracy, but directed the parties to brief plaintiffs' remaining claim of unlawful distribution under the Copyright Act. That's the whole seeding thing they were talking about. A claim not present in this case. Seeding has nothing to do with this case. They're trying to make it, which is why they slipped the torrenting thing in there that we saw earlier. But no, the time to make those claims is over. Rather, Kadrey questioned whether bad faith is relevant to fair use at all, concluded that good faith versus bad faith shouldn't be especially relevant, and ultimately held in Meta's favor, rejecting the notion that downloading from so-called pirate sites dictated or even strongly weighted in favor of liability. Yeah, see our coverage in that case, where, as I said, Chabria was trying to split the baby a bit, but even that baby splitting didn't go anywhere near as far as they're claiming. I have no idea what plaintiffs are talking about there. Plaintiffs are wrong that a stay would be premature and Anthropic should wait until the Ninth Circuit grants either petition. As Anthropic has explained, and as plaintiffs do not dispute, the Ninth Circuit typically takes 3 months and sometimes over 4 to rule on a 23F petition, meaning there is a real risk that the petition will not be resolved by the December 1 trial date. Moreover, a stay now is needed to address Anthropic's other irreparable injuries, namely the unique economic and reputational burdens, as this case rapidly proceeds through a novel class notice procedure leading up to an impending trial. Plaintiffs offer no persuasive response to Anthropic's many cases holding unrecoverable litigation costs to be irreparable, fixating instead on irrelevant purported legal and factual distinctions. You see, plaintiffs can recover all the costs they need to at the end of the trial. That's what the jury does. But if you've got all of these litigation costs that even if the defendants win, they can't recover, if you can't recover it monetarily, if there's no way to repair the damage, that's irreparable damage. So the defendants are the ones facing the prospect of irreparable damage, not the plaintiffs. A case concerning an interlocutory appeal of an order granting class certification would be distinguishable because the 23F petition would be dispositive and the costs avoidable. Anthropic's reputational harm is likewise irreparable. Courts have generally recognized as harm for your reputation, that's hard to come back from. As courts have recognized, impending class notice creates the prospect of irreparable harm, even where that notice has not yet been approved and the precise degree of harm is uncertain. Nor is there any requirement that Anthropic present evidence of already lost customers and canceled contracts, but whether the applicant will be irreparably injured absent a stay. Finally, plaintiffs are wrong that Anthropic's reputational harm stems solely from the summary judgment record and thus is of its own making. Any reputational harm from the summary judgment record is distinct from and pales in comparison to the irreparable harm from the heightened emotion and awareness of the lawsuit that class notice would bring if erroneously sent to millions of class members. The Ninth Circuit should be allowed to resolve Anthropic's Rule 23F petition before that irreversible injury manifests. A stay will not harm plaintiffs, despite colorfully alleging that Anthropic is purportedly hoarding class members' stolen books in its central library forever. Plaintiffs do not dispute that they seek only money damages, and the Ninth Circuit is clear. A plaintiff has not made a strong showing that a stay will cause it irreparable damage where the relief which it seeks in the district court action is monetary damages. You can always recover monetary damages. Plaintiffs contend that unauthorized use of IP rights constitutes non-compensable harm, but that principle does not apply here. Their only cited authority addressed the unique harm of a stay pending a patent re-examination where a delay would place the patent in limbo for the majority of its remaining life, and when it was over, they wouldn't have as much time left on the patent. So that would be an example of irreparable harm. In any case, plaintiffs here do seek compensation, precluding any argument that their harms are non-compensable. A stay would vindicate the public interest in the efficient use of judicial resources, including the time and resources of the court, the parties, and the jurors, whose work may ultimately prove unnecessary if Anthropic's interlocutory appeals are successful. Plaintiffs' caricature of an idling case, while Anthropic pursues discretionary appellate relief that may never materialize, falls flat. Anthropic's requested stay would only last until the Ninth Circuit can weigh in, and it will be extended only if the Ninth Circuit were to grant interlocutory review. Nor would granting a stay here be an indiscriminate pause. This case raises precisely the type of novel, important, and broadly consequential legal issues that prompt courts to grant interlocutory review. Before Anthropic is subject to massive class notice, extraordinary settlement pressure, and a judgment of potentially hundreds of billions of dollars, the Ninth Circuit should be permitted the opportunity to clarify the rules governing this developing legal landscape. Because you've got so many cases, you've got this one and you've got Kadrey v. Meta, and they're both in the Ninth Circuit. And the judges are already contradicting each other. And then you got all sorts of other cases as well. Some of them are in the Ninth Circuit, some of them are in like the Second Circuit and others. But the other circuits might be looking to the Ninth Circuit for judicial notice. Because if the Ninth Circuit rules one way and the Second Circuit rules a different way, that's called a circuit split. That's where things are more likely to go up to the Supreme Court. So the circuits are going to likely take judicial notice of what the Ninth Circuit does here, so this is really important. So once again, we see that plaintiffs are just in hysterics. They have nothing, and we just need some clarity on how these cases are going to move forward. And hopefully they get it. I think they will. Judge Alsop seems reasonable. But time will tell. We will see how he rules, and you'll hear it from me because I am the only YouTuber covering these cases. So please, if you appreciate that, go to donate.bogosity.tv and give whatever you can to keep me doing what I do. Also, comments for the comment god, shares for the share throne. Sharing this video does a big help too. If you can't give anything monetarily, share this video around everywhere you can. Get more eyeballs on these. Because right now, the only eyeballs they're getting are ones that are hideously biased in favor of the plaintiffs. You want the truth? You want a balanced look at this? You want someone who's actually going through these briefs and telling you about it? This is the place to go. So I hope to see you back here for more. I hope you subscribe. See my videos on other things as well. Thank you so very much for watching. Until next time, stay strong and be free.